Well, here we are again, our next episode of From Queens to Cleveland. And here I am with Matt Deliberato from Cleveland, Ohio. Matt, you want to say hello?
Hello, everybody. I'm so glad you're back because today is an exciting topic, right, Andrew?
Oh, yes, it is. And I am Andrew Geloza from the Estate Planning and Elder Law Group here in New York City, Queens, New York, Glendale, New York, to be exact. We address ourselves in our neighborhoods here in Queens. So yeah, I'm in the neighborhood of Glendale, and our exciting topic is we're going to talk about Medicaid and how we use trusts to get qualified, and then we're going to talk about what most people are scared of, the estate recovery aspect of the Medicaid laws.
Yes, part one was covering Medicaid and how it really works. So that was good. If you have not seen part one, you should probably review part one before part two, although not necessary. You can jump right in anytime.
Correct. So why do we use Medicaid trusts to help do Medicaid planning? We do that because there are certain financial limits, or there are certain financial requirements that you have to meet in order to be eligible for Medicaid benefits. So you're entitled to have a certain amount of assets and possibly a certain amount of income as well, in addition to being medically qualified. You need to have certain qualifications: age 65, older, blind, or disabled, or have other needs even earlier in life to qualify for long-term care Medicaid, right? Matt, what's the difference between long-term care Medicaid and just what Medicaid most people think about?
So yeah, as we talked in part one, Medicaid has so many different parts of it, right? We have SNAP in Ohio, we call it SNAP, which is our food assistance. We have, welfare payments. We've got assisted living. We have in-home, we call it Passport, right? In-home Medicaid, in the community, that is. And then nursing home, skilled nursing Medicaid. So there are a variety of different programs for Medicaid that we deal with, but I want to take a step back and just say that there are really two people that we see, two clients, and correct me if you think I'm wrong, Andrew, but two clients we see, it's either crisis or pre-planning. So let's knock off crisis right away, right? And then we can go into the pre-planning with trust. Crisis means you're already in the facility and you need care. So there's a difference if you're single or if you're married in Ohio. I don't know about New York, but a community
Same.
spouse, yeah, community spouse is treated much differently. In fact, I have a case now where we're saving about 98% of the assets for the community spouse. So it's amazing to think that, in this case, I've got a woman who has IRAs, the husband has IRAs, and we have to liquidate in Ohio, we have to liquidate those IRAs in the husband's name, again, assuming he's in the nursing home, and then annuitize it for the benefit of the spouse. On the flip side is for the wife's, the healthy spouse, right, the one not in the nursing home, we have to create an annuity and put them in payout status. And I don't know if that's the same in New York, but if it's in payout status in Ohio, it's an exempt resource. It's not considered a resource.
That is very similar in New York as well. When you're in
Good.
payout status, the asset is an exempt asset.
Good, good. And then when you're single, of course, you have to get down to $2,000. There's no question. Now, whether it's crisis or pre-planning, we do use trusts. Trusts are the key to doing this. Here's the biggest problem. The biggest problem is the attorney you go to. How many times, Andrew, do we have someone coming in saying they want a second opinion and they have been told they have to create an irrevocable trust in which you have to get a tax ID number, you have to give up control, you have to give up access to the money, you have to do all these things in order to get that 5-year clock ticking? Because remember, Medicaid has that 5-year clock. If I go in tomorrow, they ask, what did I do in the last 5 years? Did I give anything away? So in our world, Andrew and I both practice this. We do irrevocable grantor trusts. Maybe you can go into, Andrew, a little bit about what those trusts do. Why are they? What does that grantor mean?
Sure. So the difference between a grantor trust and the type of trust that most people think they need to use is that when you make a completed gift to a trust, in other words, transfer away all rights of ownership to the trust, you now have a non-grantor trust. that property comes out of the grantor's estate and is not a part of the grantor's estate when they pass away. If you have rights that you retain, then it's usually called a grantor trust. And a grantor trust allows someone, the grantor, to still maintain certain aspects of control and make certain changes. The other type of irrevocable trust, generally a completed gift trust, or a tax all-purpose trust, or an irrevocable life insurance trust, what you're doing is you're giving away all of the rights of doing anything, making any changes, changing beneficiaries, who gets what, how, and when, changing the trustees, who takes over, maybe even not allowing you to be, or the grantor to be, the trustee of the trust. And that's also a state-specific thing, right? So in New York, the grantor of a Medicaid trust, I call it a Medicaid trust because it's the simplest way of calling it. My Medicaid trust is, like Matt's, an irrevocable grantor trust, where in New York, it allows for the grantor to be the trustee of the trust and still qualify for Medicaid.
And get to keep control, right? I mean, that is ultimately how many people come in and say, I want to protect my money, but I don't want to give up control. And that's what we can do.
And they also want to know that they can have some access, because the truth is also, when you're dealing with those non-grantor type trusts, you may reserve the right to income. You still may reserve the right to income, but if you do, you also make that income recoverable too. So it's that income is susceptible to having a spend down requirement. Whereas by using a grantor trust, by not giving the right to income, you're basically also protecting or shielding the income as well.
Yes. And ultimately, in a situation where you keep the income, you're doing this in pre-planning, we just shut down the income if you'd have to go into a nursing facility, right? We just shut it down because there's no need to get income on those assets. I just want to preserve and protect them. That's all my goal is, right?
But you have to make that decision when you sign the trust, because you can't in the future give the right to income, but you can in the future take it away.
Right, right. And Medicaid is trying to challenge these things all the time. We just had one. Andrew had a case. I had a case. In my case, they told me it wasn't irrevocable. We opened up page 1 and it says, this is an irrevocable trust. I said, okay, now what? What's wrong with it? Well, they're the trustees. And I said, okay, show me in Medicaid law, or really trust law for that matter, where they cannot be trustees. So we won the case, and our trust is approved. So that's a good thing.
Right.
They're powerful documents. It's very complex planning. It is not simple, but we're here to make that easier. We don't want you to understand page 1 to page 80 of this trust. We want you to understand the purpose. We want you to understand what it does, why it does it. So we do, and Andrew does the same, I'm sure. Again, correct me if I'm wrong always, right? But we do funding for these trusts. And when we talk about funding, we talk about what you're allowed to do in these trusts, what you're not allowed to do in these trusts. So for example, Andrew, can I just write a check to myself from that trust at any time for anything?
Not a good idea if you want to still get Medicaid and you don't want estate recovery.
Good, because what I say is the irrevocable grantor trust gives you all the cans of the revocable trust. Cans meaning I can be a trustee, I can be a beneficiary, I can, right? I can amend it, I can do things. But it's only one cannot of the irrevocable side, and that cannot is you give up direct access to the money. And so people get freaked out right away. That's the first thing I hear. Well, don't talk to me. I don't want to hear it. I don't want to give up access to my money. And I said, no, you don't want to worry about access. You want to worry about control. I'd much rather control my money than own it any day. I'd rather have it in trust and be controlling it. That's the key. The key is to make sure you are in control, and that's what we'll be able to do for you.
Right. And on the flip side of it, what we also deal with is HRA in New York City, or Department of Social Services in most other counties across the country. And what we're dealing with is whether or not this actually creates a real benefit for the applicant. That's what they're generally looking at this thing. What benefit does the applicant have here? And if they're under their thinking that if the applicant has any benefit at all, then the whole entire trust is an available asset to spend, and for them to require you to spend and spend down all those assets in order to pay for care. And then Medicaid will then come on the scene and give you benefits. So, and patently, they're wrong. They're wrong
Yes.
about that interpretation. We're continually fighting against those interpretations. And in fact, as Matt said, we had a case where we had certain language, which were standard language in a trust, where a trustee had the right to do certain things in dealing with any real property that the trust owned, including, to build improvements or repair improvements on real property. My client was an 87-year-old gentleman who had about $1 million in his trust and had this provision in there, but the guy never owned real property. 37 years he's been living in the same apartment, and he doesn't own any real property. So they say, but he can do it. So, which is another reason why, as Matt pointed out, we allow our grantor, you, our client, to have control. We give you access through the rules we create in the trust about allowing beneficiaries, usually trusted people who can be money or property can be transferred to. And we also have what we call a trust protector, or something built into the trust to be able to make the changes that the grantor cannot make. Because you're creating this irrevocable trust. If the laws change or if there's pushback on the document, something has to be available to make those changes, and we create a trust protector. So what we did in this case is we, as the trust protector, acted to remove the language that was objectionable, and then the gentleman got his Medicaid.
Yeah, I'm constantly amazed because in our case, we had a caseworker who was on the appeal. So instead of putting an attorney in that spot, they put the caseworker on. And so when they asked for what are your basis in law for these claims, I mean, she was like, I don't have anything. And I was just amazed and shocked. It is just a system that is constantly, they want to challenge us, and gosh darn it, we're going to pull through every time. I'm going to knock on wood.
I'm not with you.
Yes, we have not had a case where it went south on a trust. So,
Right.
and the other question I think, Andrew, that people ask all the time is what happens when they change the law? I heard they're going from 5 to 7 years, which I don't think is going to happen. We can have that discussion later, but I always say they can't go retroactively, right? So if you create a trust now and they change the law, you're covered. So get in and do them, because it is so important to protect those assets, and nobody realizes it until it's too late. And when it's too late, that's when we get the call. You need to proactively do it now. Now is the time.
It is. And why that's the same difference between the crisis planning and
Yes.
pre-planning.
Yes.
In pre-planning, we can protect 100% of your assets if you act early enough.
Mm-hmm.
With crisis planning, we can always protect about half of your assets, no matter what.
Right.
Most of the time, somewhat more than half. But the point is, if you're concerned and want to really protect all of your assets, then it's a good idea to start earlier. And most people are afraid to start for the reasons that you gave, Matt, that they don't want to give up control. They won't have access. They're going to have to give up all this stuff, and someone else, they're going to have to go to their kids and have their kids write their checks for them and things like that.
It doesn't work that way.
It doesn't have to work that way. It works that way in many other places. Many other attorneys create trusts that do not allow for the grantor to be in control as the trustee. And so therefore they do have to get the checks written by their kids because
And
they're not in control.
right, exactly. So we've seen it done wrong more than done right in other offices. And that's why you need to come in and figure out what you've got and what we're going on. And it's a good time to mention that you also need a good power of attorney, a legal financial power of attorney. I just had a couple who came in. They said, Mom's going, she's in the home. I'm like, oh, great. Here's what we can save you. I think it was 60% of the assets. It was a nice big number. They were all excited and happy. And I said, well, let me look at your power of attorney. The power of attorney does not allow to create trusts. The power of attorney does not allow any gifting. And so I basically said, can mom write a check to you? No, mom's not competent. So we can't help them. They can protect nothing.
Or they can get
And
a
they,
guardian.
yeah, I mean, in Ohio, they are now starting to become open to Medicaid planning, but really traditionally in our courts in Ohio, it's not a good sell.
Right.
It's like it's the government saying, "Oh yeah, you don't have to pay us," right? It's inherently a conflict
Right.
for them to do Medicaid planning for any of their client or guardians, wards, I should say, right?
Yeah. Which
Yeah.
is horrible. Which is
But
really
in
horrible.
in New York, you can do Medicaid planning through a guardianship.
I think that the courts are generally more aligned with and in tune with the idea that you don't have to spend down all of the assets of a human being.
That's
And
fantastic.
that generational wealth is an important thing.
Yeah,
It depends. It depends which judge you get. So,
right.
but then again, this is the difference between doing pre-planning and not doing pre-planning.
Correct.
Simple power of attorney is great until it's not. As
Right.
you point out, I have the one that I got last week too. They come in, there's no gifting powers.
Yeah.
If you
Yeah.
have no gifting powers, then how are you going to transfer whatever assets that haven't already been transferred into a trust if you've used a trust? Or how are you going to transfer away any of the assets that they have to you or to others as the children of the person who needs care? You don't have the authority to do that. You have a limited authority. In New York, until 2 years ago, the limit was $500 per year for all of the gift transfers an agent could make.
Wow.
Now it's been raised to $5,000 per year. Still not adequate.
No.
So if you don't have something that's going to raise and give the power to do whatever is necessary to get benefits, most likely what's going to happen is you're not going to get benefits because Medicaid is going to look at the trust and they're going to look at the power of attorney and they're going to say, well, you don't really have the power to do this planning.
Right, because a lot of people come in crisis without a trust. So if that power of attorney doesn't authorize you to create that trust, I mean, I've seen a lot of power of attorneys lately, they have the power to create a revocable trust. Well, that doesn't help us.
Yeah.
You have to be specific on what you do. And I always say, I apologize for my industry, right? I'm sorry that the majority of attorneys out there doing estate planning do not do Medicaid planning. And that is the key difference. If you are in an office, you got to ask, how many applications for Medicaid do you file?
Right.
What's your success rate? What's, all the questions you need to do. Do you even do Medicaid planning? Oh, no, we don't do that. Well, then I shouldn't be doing my estate planning there either.
Well, you first of all have to get over the stigma of people thinking of getting Medicaid. So most people think that
Ah,
Medicaid is like
yes.
welfare, right? They think that it's the kind of thing that you're taking advantage. Oh, you
Yes.
have this money. I have financial advisors who said, my clients are never going to need Medicaid. They have more than $2 million. They're never going to spend through that. I said, but what about the fact that they want to give all of that $2 million to their family?
Yeah. Yeah.
Right? So
Yeah.
yeah, we get the pushbacks on all of that. It is kind of crazy. And the real truth is that we see such great benefit of doing this planning. You've paid into this system. Medicaid is something that all of us through our taxes have paid into, and we're only able to get access through them if we understand the laws that apply to this area and are able to do proper planning to deal with those laws, just like the tax laws, right?
Right.
Everybody hates paying taxes, but everybody makes a complaint about using planning to help get qualified for Medicaid.
Right. Right. No, and it's so true. And I think the system is broken, right? It's not breaking. The system's broken. And it's our job to help you navigate through it because
Right.
it's there, it's available. Like Andrew said, you've paid into this system your entire working life. This is not something that you should not take advantage of. This is something that is there for you. It's available. We should use it.
Absolutely, 100%.
Yeah.
And, it's been a great conversation about Medicaid and using trust to do some planning. I think that, I personally think that we're going to stop here and we'll get to estate recovery in one of our next podcasts because I don't really want to rush through that either.
Right, right, right.
You know, so I think we
Good.
did an adequate job of it. If you're more interested and you're interested in getting more information, we can be reached, the Estate Planning and Elder Law Group here in Glendale, New York, at epelg.com. That's our website, or info@epelg.com. And Matt?
Yes, you can reach us at icanprotect.com. It's Deliberato Law Center in Cleveland, Ohio. We are actually in Independence right on Rockside Road. And yes, icanprotect.com, or you can send an email to info@icanprotect.com. Fantastic.
Yeah.
This is good stuff. I am so excited that we got part 2 out, because there's so many people out there that we can help. We sent out, and on our Facebook last month, we protected $839,000 last month for clients.
Nice.
And that is just the tip of the iceberg. We can do so much more. That's crisis only. I didn't even count pre-planning. So, you know, that's exciting stuff.
Yeah, the crisis part too. So I mean, sorry to go back into our topic here.
Right, right, right.
But the crisis thing is people think that it's gone. There's no way they can do anything. They've waited too long, and nothing. We can't do anything. I have people who come after spending down $400,000 in a nursing home. Ask me
Yes.
what we're down to 100,000. What's going to happen? We'll get down to 100,000. Is there any planning we can do? Well, you should have made a plan to come to me when you had 500,000, because we could have protected it at least half and probably
Right.
3/4 of it. So
Right.
again, it is a matter of timing.
Yes.
We don't talk about pre-planning because we want you to come and do things without a really good reason. The really good reason is that it's remarkably much more expensive and more devastating to wait until your loved one is in crisis to come and do planning.
Yes.
Doing pre-planning gives you the ability to take control of this situation, because you're basically forcing what the look-back period is going to encompass.
Okay,
Because,
go ahead. I'm sorry.
yeah, because when you put your property into this type of trust, you start that look-back clock, and that 5 years from that date, they can't look back anymore to claim that the property that you've transferred is subject to creating a penalty for you. And that's really what we talk about. The look back creates a penalty measured in months, and that penalty is, you know, like you transfer away in New York. If you transfer away $280,000, you have a 20-month penalty. So that's nearly 2 years you're going to have to wait to get benefits, and you're going to have to spend down your assets. If you transfer away a house, most houses in the city of New York are over $560,000. $560,000 transfer will give you a 40-month penalty. That's nearly 4 years that Medicaid will not give you benefits, and you have to pay out of your pocket.
Yes. And I know we're wrapping up, but it goes one more point I want to make, and that is the nursing home in general will tell you, don't worry about an attorney, we'll help you apply for Medicaid. That is the worst thing you can do. I have the
Or they'll
famous,
tell you to transfer over your house. Just come in.
yes, yes,
Give
yes,
us the deed to the house. You'll stay here
yes.
for the rest of your life.
Right, right, right. And it doesn't work that way. In fact, the famous case in Ohio is a woman gave away basically everything she had. She had about $70,000, gave it all away, and needed nursing care in 4 years and 11 months. This is a true case. I'll give you the case site, Andrew. You won't believe it. An attorney files an application. She gets a penalty from 4 years and 11 months for the next 10 months. And now it's extended beyond 5 years of penalty. And the family had no money to cover that. So it's always good to have a Medicaid attorney on your side.
Right.
Don't file an application without consulting us.
The look back period is 5 years. The penalty period is unlimited.
Yes, yes, yes. Well, thank you all. It's a great time. It is hopefully as exciting for you to listen about Medicaid it is for us to talk about Medicaid, and we will see you on our next topic.
Bye, everybody.